cannot set an example of true interpretation of Article 194.
Well, sir. Yes. Next.
The word, the context in which why they said anything includes everything is for this reason itself. Whether defamation can be anything. This question was posed and answered. Anything means everything. All right. Now, my lords, for instance, can there be more blameworthy conduct, permit me to use, of a legislature when he criticizes the honorable judges? According to me, that is, my lord, can it be more blameworthy? Even that has been protected, though their lordship said it is unfortunate. But there were, if lordship permit me, there were instances where in Kaveri dispute, two honorable judges directed the Karnataka state to release water in the last regime of the present government. The House legislature collectively took a decision that we will go back to the court. Obviously, they were milder in their terms, but it was almost a defiance of the court. But I collectively took that. No, I'm only. No, I'm going.
Defiance can't be projected to this case. Defiance is defiance or the independence of the legislature to undo what the court has done. That power is there. That is all. Go to the parliament and to the state legislature.
So that was not a case of that.
Wherever we have passed judgments, it is not that they're weeding out.
I'm only in those discussions. Obviously,
doctrine of invalidation is always there.
I gave examples. There have been instances where the honorable judges have been criticized. That cannot be a better example than what's an utterly word to another member of the legislature. They both of them are blameworthy. I'm putting it. I'm not saying one is better than the other. If that has been given protection for this reason, saying that no, we can't do anything about it because though he says it is unfortunate, because the reason is this. But I'll once again emphasize. It is necessary, my lord, that protection, that independence is given to the members of the legislature. If the in the current parliamentary system of government, or Westminster model where the ruling party also is the head of the executive, lordships may have to see the nexus. If the executive is allowed to dictate the terms, it would lead to consequences. I cannot get up and ask a question to the Honorable Chief Minister. I cannot blame the government of undoing. That would either result in defamation or some sort of an intimidation. If that fear is crept in, then it would result in, if the executive is allowed to overtake this, then it will result in turning the whole concept of independence itself according to. Therefore, Tej Kiran's case and A.K. Subbaya's case, both of them reiterate that position of law.
Yes.
But I also wanted to bring to Lordship's notice Article 212. (212) subclause 1, the validity of any proceedings in the legislature of a state shall not be called in question on the ground of any alleged irregularity of procedure. Kindly see subclause 2. No officer or a member of the legislature of a state in whom powers are vested by or under this constitution for regulating the procedure or the conduct of business or for maintaining order in the legislature shall be subject to the jurisdiction of any court in respect of the exercise by him of those powers. Mr. Belliappa is arguing exactly contrary to 212 subclause 2 when he says this person was not speaking when the house was not in order. He was speaking beyond the power which is vested in him. These are all matters of procedure, conduct, controlled by the head of the house. And he cannot now, ultimately, who has to determine that? This has to be determined by the head of the house itself and not by a court under Article 226, 227. And the court under Article 226 and 227, the only exception the Honorable Supreme Court has made as to when it can actually determine this issue. But why I am emphasizing on this is these two questions which has crept in the mind of the court as to whether he can speak something outside his duty, etc. the Honorable Supreme Court in Raja Rampal's case lays down a very fine distinction between the jurisdiction of the court as well as proceedings of the legislature. What is said by me in the legislature that day on 19th December, I am subjected to only to the order of the House by the chairman of the Legislative Council. Whether I spoke in excess, whether I spoke as part of my duty, whether the House was in order or not, these are all matters, according to me, to be controlled and decided only by the chairman of the Legislative Council in this case. And under what circumstances 226 can be invoked to determine this, is it Raja Rampal's case? In that written submissions itself, Lordships, I'll kindly find it paragraph 16. 17. Conclusions. No, not this. Conclusions. Last conclusions. But in that compilation, Lordships may kindly see.
Yes. Para 656 and 657.
But I have always maintained, it is very difficult for us to catch up with Lordship's speed.
Oh, there.
It is very difficult to catch up. Page 160, 448.
448.
440. Conclusion. I'll just bring one second. But there is a conclusion is Lordship Justice Ravindran draws. Finally, as to how 226 and inter alia, I'll just point. But where they emphasize that the coordinate organ of the constitution must be equally respected.
Conclusion lilla.
7 conclusions their Lordships have drawn. I'll just point out. But I had all done this note. I don't know. We lost it in the book. 749. No. 1 second. I'll just.
That's in paragraph 656 and 657. Page 414 and 415.
656.
657. If what you are wanting to submit. Conclusionally, there is nothing like that.
In this kind of, yes. No, more than, I'll just point out, there are about 7 tests they have laid out.
Yes.
Just kindly give me a minute, not more.
Yes.
There was a case where they were expelled.
Are you reading Justice Ravindran's view?
Ravindran or the one separate view.
That's a dissenting view.
So there he takes a slightly different view.
But this remarks,
Balakrishnan.
703, 704.
Yes.
That is the concurring view.
Yes.
This para 643.
Yes, 643. Open Raja Rampal. Yes, this is what Raja Rampal.
You can point out later.
Yes, I'll point out.
The SPP.
There, they lay down 7 tests. Some of them immediately, if I recall, they say fundamentally, normally the decisions of the legislatures must be respected by the court under Article.
That is in 640.
640. And only in exceptional cases where there is violation of Article 21 or Article 14. For instance, in their case, that case, but they were ousted from the expelled from the parliament by Somnath Chatterjee. In fact, that time he was a speaker, and he expelled them from the house, and they moved the Honorable Supreme Court. Honorable Supreme Court actually quashed that order of expulsion of the Honorable Speaker. And I must state in the same breath, This judgment came in for a lot of issues when the matter went back. The House rose in protest saying that we will not recognize the judgment, and that's a different story. But the fact of the matter is, they delineated exceptions by saying only in respect of these matters we will interfere under Article 226, or for that matter, Article 32.
Yes.
Not in other matters.
We'll hear the SPP.
I'll just conclude, try and conclude. The last page is the conclusion of that we have said.
Nimma conclusion.
That the word legislature, these are the propositions.
So you're on the fourth proposition throughout.
Yes.
Anything said.
Anything said.
Not anything done.
And not anything done. Certainly.
The distinction, the subtle distinction you're wanting to make is not anything done, but anything said.
Anything said.
Ajit's case was something done.
Ajit's case only, they actually broke
something done.
Something done. Something done.
We'll see.
Yes. But one sentence I have to say. I'll be failing in duty if I do not convey the instructions of that. But insofar as the present incident is concerned, we have the deepest regard and respect for the respondent number 2. She's a lady of some reputation, honorable minister, irrespective of whether he has said or it has hurt the feelings. There could never be a situation where any woman could be hurt. I am not for a moment justifying, assuming it is to be true. Therefore, the honorable speaker or the chairman took a very right decision. He said, these are matters which we should leave it here and proceed further in order to enhance the responsibility of the House. Therefore, my lords, I don't think, my lord, he has also been in public life. He has come from a student struggle. No, I'm not saying it's a student struggle. So has respondent number 2. So both of them are now ultimately members of that House, which ultimately we are trying to interpret and protect. Therefore, anything said, though legally I would say anything said is everything said, but not necessarily in all cases for justification. The deepest respect, I must convey, not by me, through the petitioner, deepest respect, highest regard for the respondent number 2's achievements, their modesty and their nobility is conveyed to Lordship's so that things are resolved in the manner it is required.
But the contentions have to be answered.
Yes.
SPP sir.
Yes, Lord. Lord, it's all about anything said. Lord, 7 judges have said in Sita Soren's case is what, my Lord, I will take your Lordship to. Kindly take, my Lord, 194.6, the conclusion drawn by 7 judges of the Supreme Court. Kindly see, my Lord. Your Lordship goes to para 7, my Lord. The conclusions drawn are at page 742 at para 194. Your Lordship gets it?
Yes, yes. Para 194, yes.
Yes. Now kindly turn to 194.6. Lord, I straight away take your Lordships to what the judges have said about anything, the expression anything said in respect of a speech or a word given. May I read, Lord?
Yes, sir.
But 194.6, the expressions anything and any must be read in the context of the accompanying expressions in Article 105 plus 2, 194 plus 2. The words in respect of means arising out of or bearing a clear relation to and cannot be interpreted to mean anything which may have even a remote connection with the speech or word given. Now, my Lord, admittedly, there was a complaint before the speaker, and the speaker has also, my Lord, the first contention was that the speaker has given a finding. Now, let me take your Lordship to the speaker's finding, my Lord, that the House was not in session and it was not in good taste that these utterances were made.
SPP, sir. Judgments mugsbidi. Then I'll get into the facts.
Lord, I would want some little time, my Lord, even after 2 days, I would be there because while coordinating with the respondent number 2's counsel, he said he would take some time. Therefore, I was to come there. Otherwise, my Lord, now I could not come. The judgments, I will not rely on any more judgments except not clarifying these judgments. and Ajit's judgments, my lord. I will
All
not have anything but to clarify. Give me 2 days time, my lord. That is all I require. My lord, on facts now. Could your lordship go to the finding of the speaker, my lord? He sums up saying that the house was not in session. My lord, may I take your lordship to...
Chairman ruling we cannot rely. If he amount.
No, he is not the,
No,
I'm
it is
not-
a
I'm not
house
relying
ruling.
on
they're
that.
not relying on that is what
I'm
is
not
said.
relying on that. The facts. And what
It is in our favor, I have not relied.
yes, because they have relied it.
Yes. Yes.
And
yes.
what is parliament? What is defined as parliament? My lord, now kindly turn to page 54, my lord.
Yes.
54. That's the finding given by the speaker. It starts from 53. My lord, all that he says is, the fact is that when the house was not in session, kind of filthy language is used. It is not in good taste. It is extremely disrespectful. See the tirpu, my lord, at the para 54. There is what is shown as tirpu. The lordship gets it?
Yes.
Yes, my lord. He is
No.
given a finding.
Well, SPP sir, if
Yes,
if you're wanting time, tell me, I'll take it on Monday, no problem.
Yes, my lord. Yes.
But after all this, then adjournment agalla.
Alala, because respondent number 2 is seeking time. I'm not seeking time. That's why I thought, my lord, I will also sail with them and argue on.
Second respondent.
Yes,
I
sir.
wakalat yesterday only, my lord. We will make a detailed objection on this.
When?
Soon, my lord. Any short accommodation.
Monday.
Yes.
Monday?
All right. We'll take it on Monday then.
Yes,
Monday at 4 p.m.
yes, sir.
Lordship permit me to appear on VC
Online.
on Monday.
Whenever I insist. Yes.
My lord, may I make one submission, my lord, with respect to serial number 1. I could not join the matter due to some technical glitches.
Which
Lord,
one, sir? Bangalore
serial
list.
number 1, my lord, that's an animal trophy matter.
We'll see. Wait. Yes. Heard the learned senior counsel Prabhuling Nawadgi appearing for the petitioner who has completed his submissions and reserves liberty to submit anything in rejoinder to the submissions of the learned SPP or the counsel representing the respondent number 2 complainant. The second respondent, counsel for the second respondent seeks short accommodation to file objections. Therefore, list this matter on Monday at 4 p.m.